come before the court today is State of Ohio versus Christopher Moore. Each party will have 15 minutes during which to present their arguments. The appellant may reserve up to 5 minutes. Just please let me know when you take the stand, when you approach the podium, and I'll do my best to keep track of the time for you. The arguments are being visually and audibly recorded to be posted online, so please keep your voice up, remain behind the podium. We've read your briefs, and we are ready to begin when you are.
May it please the court, my name is Attorney Joseph F. Salzgeber, and I represent the defendant appellant Christopher G. Moore in this matter. I would like to reserve 5 minutes for rebuttal, though I don't expect that this will take the full 15. This matter involves, Your Honors, Mr. Moore, who accompanied his associate, April Smith, to the Wadsworth Walmart in February of 2018. She engaged in what can only be described as attempted shoplifting behavior. He was present along with her. When she was confronted in the store, she abandoned her shopping cart, including her person identification, which made it relatively easy to locate her, or would have had she had a normal address, stable address. She was subsequently located and arrested on a warrant. My client was present. He was also charged as an accessory to the shoplifting offense. He ultimately pled to a reduced charge of attempted theft after initially denying that he had anything to do with the shoplifting offense. In this particular instance, we're challenging only the sentence in the case. We're claiming in our sole assignment of error that the trial court erred and abused its discretion by sentencing Mr. Moore to the maximum jail term of 90 days without consideration of all the sentencing factors under Revised Code Section 2929.22. In this particular case, specifically the nature and circumstances of the offense, it's relatively clear from the PSI, which was included as part of the record in this case, that my client has a drug problem. He has admitted to that drug problem. He had relapsed sometime shortly before the incident in February of 2018. However, there's no indication in the record that the trial court considered any of the sentencing factors outlined in 2929.22 other than Mr. Moore's prior criminal record. I think the PSI report, as I argue in the brief, makes it clear this was not the worst form of the offense of attempted theft, where even the official version of events indicates that it was Ms. April Smith who did the actual compilation of the goods that she was attempting to steal. She abandoned the shopping cart full of merchandise, including her own purse, inside the Walmart Supercenter before they exited the store. My client apologized, took responsibility for his actions. He advised the trial court that his drug addiction was the main factor in the offense, and where he had relapsed after being sober for 2 years. And he had, this offense took place after his relapse. Based on the foregoing and the fact that he was minimally involved in this particular offense, that it was not the worst form of the offense, and he accepted responsibility, it's our argument that the maximum jail term of 90 days was inappropriate. We're therefore asking this court to remand for resentencing back to the trial court. Thank you.
Please, the court, for the record, Tom Morris, representing the City of Wadsworth County, or the state of Ohio as well. This case, the defendant pled guilty to attempted theft. Originally he was charged with theft. It was reduced to attempted theft. It takes it down to misdemeanor of the second degree. Misdemeanors of the second degree, as you all know, has a 0 to 90-day period of incarceration option that is open for the judge to do. It's got to be within that range. It has to be based on reasons under 2929.22, but you don't, case law says, you don't have to put the reasons on the record. He ordered a PSI, the judge did in this case, pre-sentence investigation to make a determination of what would be a fair and appropriate sentence. Found out this young man is 36 years old. He's had 23 convictions since 2000. The only time it averages out about 1 a year of convictions. The only time we would have a break is when he was in prison. He was in prison 3 different occasions for a total of 4 years. So in the 14 years left that he had out, he was averaging more than one criminal offense a year. These were out of our jurisdiction too, out of Wadsworth's jurisdiction. He was caught doing thefts prior. He was violated from probation every time he was on probation. He was a horrible candidate for probation. While on bond, he admitted that he was using methamphetamines and came to the pre-sentence investigation having freshly used methamphetamines. I would submit to the court that the reason the judge gave this gentleman 90 days was because he couldn't give him 180 days, because it was a second-degree misdemeanor. It was within the parameters that's set forth by the Ohio Revised Code. It was an appropriate sentence. I'm sure the judge did it because of his record, because of everything that's under the subsection as it was reviewed by the pre-sentence investigation. The fact that he didn't mention it on the record is not something that he has an obligation to do.
Thank you.
I'll waive rebuttal.
All right. Thank you both for your presentations. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and that of the Supreme Court. It is